you.
SJC-11265, Deutsche Bank, National Association for
Yes, Counsel, good morning.
Good morning. Richard Briansky on behalf of Deutsche Bank. Your Honors, the plain language of the policy required First American to provide a defense to Deutsche Bank. In particular, if you look at the policy itself in broad-based terms, First American was required to insure against loss or damage which was sustained or incurred by reason of the invalidity or unenforceability of a particular mortgage lien, which in this case Deutsche Bank held. In addition,
did First American participate in any way in the execution of the transaction of the loan itself?
No.
So why should there be coverage in this case?
It has nothing to do with the loan itself. Rather, this is as to the enforceability of the particular mortgage which was on the property. The particular allegations in the Carla Brown action identify both the note and the mortgage and seek rescission as to both. And under the very deferential standard imposed by comparing the terms of the complaint itself to the terms of the policy, it demanded at least initially that First American provide coverage. That's what they agreed to do. That was an attack on the unenforceability or the validity of that particular lien.
How would a title insurer be able to tell in deciding whether to issue a policy that there was anything untoward about the loan transaction, assuming that there was for a moment? The title insurer would have, I mean, it really sort of changes what title insurance is all about to go your way.
I disagree, Your Honor, and let me tell you why. Because title insurance, I think the fundamental misconception is what title insurance is. And for sure, it does involve a review of the title. But in addition, the title insurance company is responsible for issues which are off record. And if you look at the series of cases, now in this particular case, for example, if there was a fraud in the inducement, which is what has been argued here, or if there was some sort of incapacity of the mortgagor at the time, surely those are the particular cases. If there was duress or undue influence, and that was the basis of the claim to void or rescind the mortgage, those types of off-issue attacks on the validity of the mortgage are covered. And if you look at the series of cases which have been cited, all recognize that those off-series issues are covered. In particular, there's a lawyer's title insurance company versus Novastar, and it says a mortgagee's title policy protects the mortgagee against certain risks related to the validity of the mortgage itself, such as fraud, incompetency of the mortgagor, or failure to properly execute the mortgages. Instances which give rise to claims under title include where it was found that there was a forgery in the execution of the mortgage, where the mortgagor has been previously adjudicated incompetent, or where there was a lien on the real property because the mortgagor previously had conveyed the property to another.
But those are sorry, go ahead.
No, you finish.
I was going to say, but you're just suggesting there were things that the title insurance company would actually look at before determining whether, I mean, you say if there had been an adjudication of incompetency, I mean, aren't these are not really off-record things?
No, that's not true. How would the title insurance company ever know if there was a forgery of the deed? They would particularly look at the deed itself, and there would be no way to tell from the face of the deed whether there was a forgery. Likewise, there could be several instances where there is issues with a foreclosure where those would be off record. For example, if there was an issue with a publication, and they ultimately that would not necessarily be of record, and they would be responsible.
But all of these things have to do with the mortgage qua, whatever that Latin word is, mortgage qua title instrument. They don't have anything to do with the underlying transaction, with the loan, with the financing.
But neither do the claims that Carla Brown's asserting. Carla Brown's specifically stating that she wants rescission, and in part she wants rescission because this is a common law fraud in the inducement claim.
But her claims relate to the way that the note, the mortgage is security, but what's really underlying her claims, as far as I can see, is problems with the way that she was induced to sign the note. And it all relates to how she got into this loan itself, the loan itself, not the mortgage is just securing that loan, but she's complaining about the loan.
But she's seeking specific relief as to the rescission of the loan, and she claims that the reason in addition to saying the reason I signed the note was because of these misrepresentations, she's also alleging in the complaint, which is what we're bound by when we're making that initial determination, that she relied on these representations when she signed the mortgage. And I address your Honor's attention to paragraph 49 of the complaint itself, where it identifies specific coercion by GMAC and its broker. And that GMAC and its broker, and that coercion is what caused her to sign the mortgage, which is what she specifically alleges. That's in there several times. Each of the claims seek rescission of the mortgage in addition to the debt instrument itself. I think, sorry.
Should our legal principles, which we use to examine the duty to defend in liability policies, be the same for a title insurance policy?
We dealt with this briefly before, but in this particular case, it should be as to determining whether there's an obligation to defend. And I don't think there's been any justification for varying from those principles.
If there were justification, it would be because they're very different in their purpose.
But with regard to the particular defense obligation, I think that is very similar, in that what the insured bargains for is a defense of whatever is covered under the policy, and it's a comparison of the policy to what the insurance company had agreed to insure. And it's got to be expeditious.
So the basic premise is that for whatever reason, this title insurance policy provided a duty to defend in claims in which the title insurer may not have screwed up.
This is a standard form title insurance policy, and for sure the title insurance policy could have taken exception to fraud. And in fact, if you look at the policy, they have taken an exception to when the insured itself participates in fraud, because they've excluded matters created, suffered, or assumed by a particular insured. But what they haven't done is excluded this particular case where a third party who they anticipate at the time of issuing the policy is going to take a mortgage by assignment and doesn't have knowledge of the underlying fraud. In that particular case, they're both in the same, First American and the insured are both in the same position. Neither had knowledge of the underlying transaction, neither was in a better place to identify the particular fraud, but the insured in this particular case relied on that title insurance policy when it took the assignment. And in fact, facilitated the assignment.
What about exemption 3? Or in other words, for consumer credit or usury or problems with the tie?
It's not applicable by its plain language.
Why?
Because there's no consumer credit claim trying to discharge, trying to determine, trying to invalidate or create.
You mean because there's no reference to the federal statutes or the Massachusetts statutes under consumer credit? Is that why?
That's correct. It's very specific. And in fact, there was a decision for whatever reason by Ms. Brown not to allege any of those particular claims. And that exclusion is very specific. In laws interpreting the exclusion of a policy required the exclusion be interpreted strictly as the insurance company has drafted them. And here, had they wanted to expand those two consumer claims, as the judge erroneously wrote in her decision, they would have done so. Likewise, if they wanted to exclude claims for fraud, they could have done so in the exclusion, but they didn't, leaving themselves potentially liable for cases like this where there's off-record conduct that the insurance company doesn't know about. And this is just a mere comparison of the complaint itself to the policy. And at a minimum, when that complaint came in, that complaint was sufficient to trigger First American's duty to defend. It specifically alleges that one of the bases for rescission is that there was a fraud. They're attacking the enforceability or validity of the particular instrument. And I know First American has argued at length that they're not responsible for off-record issues, but if you ask them specifically, in cases of forgery, in cases of undue duress, which I don't think you can make a meaningful distinction between this case and those would be covered issues. So what is the meaningful distinction between this particular case, and I'm talking about the claims as they're alleged in the complaint, and the claims that First American would admit that they would be responsible for off-record conduct. It's not so simple as saying that we go and search title, because the policy covers more than just that. And if you look at all the cases cited by First American, for sure they acknowledge that they're not responsible for the debt. And we're not claiming that they're responsible for the debt. But what they are responsible for is protecting and ensuring that we have a valid and enforceable mortgage. And the claims here asserted by Carla Brown attack that very proposition. And at a minimum, we would be entitled to a defense. If there's no further questions, Your Honors, I have nothing further.
Thank you.
Good afternoon, Your Honors. Jason Manikas on behalf of First American Title Insurance Company. I'd like to start with obviously the seminal issue in this case, which is whether or not Ms. Brown's allegations in the complaint triggered coverage. While there are three specific and independent grounds through which First American can avoid a duty to defend or indemnify in this case, being one, Section 5 of the insuring provisions, which was just discussed, as well as two specific exclusions, Exclusion 5 and Exclusion 3A. I want to start with the insuring provisions. What this case is trying to do is really expand the scope of title insurance coverage.
What do you say to paragraph 49 of the complaint?
Paragraph 49, Your Honor, if I may look at it. I believe.
Well, I can read it to you if you don't have it there.
Yes, Your Honor. In paragraph 49, there's a reference to the word mortgages, as is there a reference to rescind the mortgage to every count by Ms. Brown.
But the factual allegation is that GMAC and the broker coerced her into accepting the mortgages. So that would suggest fraud in obtaining the mortgages, right?
I would suggest no, Your Honor. She does use the word mortgages there and says I was coerced into signing the mortgages.
Right.
People often mistake, however, the note, the loan, and the mortgage, and sometimes use the terms
But we're
interchangeably.
talking about what's alleged in the complaint, right? I mean, it's...
Well, I think it goes beyond that, Your Honor. I believe that the obligation to defend is what a reasonable interpretation of the complaint is. You're not subject to the whims of the pleader. It's what a rational interpretation would be, and I believe that the case law is well established. What would the reasonable interpretation of this be? So when you go through each count at the end of it, Ms. Brown says, therefore, I want to avoid the loan indebtedness and rescind the mortgage. And you have Deutsche Bank on one side saying, well, every claim here says I want to rescind the mortgage. It's seeking rescission of the mortgage. And under the insuring provision 5 on the cover page of the policy, which says specifically that we will guarantee any loss or damage incurred by reason of the invalidity or unenforceability of the insured lien upon title, they're saying, well, that affects the lien upon title. And in fact, that specific claim was raised in the Pacific American case. And the Pacific American court, as it went through that analysis with that specific claim, specifically commented, and I think it's important to note, quote, at first blush, this reasoning seems both straightforward and sound. It then says, however, and it goes on to analyze really what the allegations were in that case and issues its ultimate determination that there was no coverage. And the specific reason there was no coverage in that case, and in the myriad of cases we cite in our brief, and the reason there should be no duty to defend in this one, Your Honor, is that insuring provision 5 has been interpreted by a series of courts throughout the country, because it's a standard policy, as, and I will quote, and this is in several cases, including the Lawyer's Title v. JDC America. It is in the Pacific American case and others. And the quote is, generally stated, the provision, which is the one at issue here, insuring provision 5, insures against defects in the mortgage itself, but not against problems arising from or related to the underlying debt. So when we're talking now specifically about insuring Provision 5 and we look at the allegations of the complaint, there's not one allegation in the complaint, Your Honor, that there's any problem with either the mortgage or title. There is a reference to rescind the mortgage, and in 49 she says, well, I was forced to sign the mortgage. But when you look at the specific factual allegations that are repeated throughout this, it is a predatory lending scheme. It is a common plan or scheme with respect to stated income loans. It is an unfair balloon payment, a switch in interest rate.
But this particular one, I agree with you, but this one says, when she says I can't, when she learned the actual terms, she wanted to stop and was forced to sign the mortgage. Isn't that what that says?
That's what
Paragraph
it
49?
says, but what are the terms that she complains about? Every term in the complaint relates to the loan terms. And I think it's important to note, and this may be a little out of order, but with Massachusetts last year, this court issued the Eaton case against Fannie Mae. And in that case, it talked at length about the distinction between a note and a mortgage and the interplay between those things. And it quoted a case from the 1800s, and there are a series of these. So this is a well-established proposition of law in Massachusetts. And the quote is that the debt is the principal and the mortgage and incident is a rule too familiar to require citations to support it. So when you have a situation, a consumer credit transaction where a person signs a loan, it's the loan terms that she complains of. It's the coercion to not void a purchase and sale agreement to acquire property. It is all of the terms of that loan that she presses in this complaint, and the rescission of the mortgage, nothing other than an incident of voiding that loan transaction. In other words, if the loan itself is voided, then the mortgage goes away. There's nothing to secure. So that is what her complaint, we believe, does, and we think it clearly does that. And in fact, when you look at the purpose of title insurance, Your Honor, you know, there's no allegation with respect to the mortgage here. There's no allegation that it's defective. It was properly endorsed. It was properly recorded. It occupies the exact place in the chain of title that it was supposed to, but for it being voided if the loan transaction is voided. There's no claim of incapacity or incompetence. There's no claim of forgery. None of those. There's also no direct attack on title here. When you look at the policy itself and see what this policy ensures, you go to Schedule A, and it represents that title is vested in Carla Brown. That's correct. It also in Schedule A says that title is fee simple ownership by Ms. Brown. Also correct. And then you look to Schedule B, Part 2, which says it's subject to the insured mortgage and a homestead. All correct. No one has challenged anything with respect to title in this case. The only challenge is that my loan transaction was predatory. I was defrauded. All of these terms were misrepresented to me, and I want out. And a function of that is rescission. I agree.
Could I just ask you these facts? She signs this mortgage, and let's say it's not predatory. I don't mean she signs this mortgage. She signs the loan, and then she, in the middle of this, there's no, you know, she's not complaining about the loan, but she says, you know, I've just had a change of heart. I really don't want to go through with this. And she alleges that the mortgage broker at that point says, you've got to go through with it. You absolutely have to go through with it. Here, sign these mortgages. You have to do it. Would it be a different result?
No, it would not.
Because?
Because she would be attacking the transaction as a whole. It would be the loan transaction she'd be attacking.
She's really attacking what happened in the securing of the mortgage, isn't she? In the facts that I just said?
No, but I will give you a factual scenario that I think may be different and that may be covered. And there are cases that I think would support this. And this would be adverse to the title company, but it's something I believe they would cover. Specifically, if you have a loan transaction that a person shows up and signs all the terms of the loan and they're not disputed or contested in any way, and then the broker, the attorney, have the person sign a document in blank. And she says, what's this document? And they misrepresent to her what that document is. They say, don't worry about it, it's part of the loan process.
But it's really the mortgage.
But it's really a mortgage. And what they do is they take that signature page and they put it on a mortgage and they record the mortgage, unbeknownst to the borrower. Borrower never intended to grant a mortgage. She would say that the mortgage was procured by fraud, the mortgage itself.
That's what I was trying to say.
That would be something that would be covered.
That's what I'm asking.
That would be a covered claim. And why? Why? Because it goes to the mortgage itself. No different than, this court's correct, they do cover record things. When a title company examines title, they examine record title. However, they do take certain risks beyond that. They do take a risk that the mortgage itself was signed by an imposter. It was forged. They take the risk the mortgage itself is defective. It has an erroneous property description on it. They take
No, but I think what you're saying, and it's a much better example than what I was struggling with, but is that if there is fraud in the inducement of of obtaining the mortgage, they take that risk.
That's correct. If it relates specifically to the mortgage itself that was procured by the fraud, I would say those would be different facts than Ms. Brown has alleged. And again, I think it's important to note, there's not one allegation as to the mortgage itself with respect to the state of title or its execution. She's never denied executing it. There's no flaws in the mortgage in this. It simply fails because it's incident to the actual loan and to the note. And I think that's important here. And really what this is a lender trying to expand the scope of title coverage to cover underwriting and securitization risks. I mean, they're really looking to recoup defense costs. And not that public policy plays into this, but for the lender to suggest these need to be covered, these non-title claims from our opinion, they're already protected. They're protected two ways. One, contractually, because when they warehouse or they have these correspondent loans or securitized loans, their PSA, their pooling and servicing agreements, give them certain rights and representations that give them rights against the person they acquired it for, and they also are equitably protected. In this case with Ms. Brown, putting aside that Deutsche Bank's already prevailed on all claims on summary judgment in the underlying case, which is why we're really talking about attorney's fees here if we improperly denied coverage.
Do we know that? I'm sorry.
We do. It was.
That part of the.
I believe, the summary judgment came down in January of this year, so it wouldn't be part of the record. Deutsche Bank and the Service of Saxon filed for summary judgment on all claims. It was allowed in January. I believe the court could take judicial notice of that. We've been monitoring that case.
I sort of left it at the motion to dismiss. So
yes, they recently prevailed on summary judgment. I still believe there's an appellate right. I think it's an interlocutory ruling, Your Honor. But as I was saying, the lender can not only protect itself contractually, but equitably, and that this is a rescission claim by Ms. Brown. So at the start of the transaction, she owned no property. After the transaction, she owned property, this house, and she was subject to a loan. If she rescinds the loan, which is really her claim here, the lender's still protected because the case law is well established that she couldn't rescind the loan, not pay the money that she received back, less potential interest and other charges, and then keep the property. So at the end of the day, for the lenders to suggest that this is something title companies need to insure, really they're just looking for a free defense and for us to offset their underwriting risk, because at the end of the day, they've protected themselves not only contractually, but equitably, and that they would get the money back. And unfortunately, given the foreclosure crisis, they may actually benefit if Ms. Brown was required to tender back all of the principal they gave her. It may be worth more than the property. I'm speculating. But for them to suggest this is something that we should do is something we would obviously disagree with.
So are you saying that we should analyze the duty to defend differently for a title insurance policy than we would for a liability policy?
I am not, Your Honor.
I guess we generally are quite liberal with regard to a duty to defend in a liability policy. It's generally quite expansive.
It is, Your Honor. I believe that.
Why is it not then equally expansive here, unless we should treat title insurance differently?
Well, I believe that the duty to defend and the case law surrounding it is expansive, and I believe that the case law suggests that title policies are insurance policies and should be interpreted the same way, and therefore the common standards for duty to defend, as we cite in our brief, should be applied to this. We're not suggesting a different standard for title insurance policies. What we are suggesting is that notwithstanding this view of the duty to defend, broader than the duty to indemnify, and looking at the four corners of the complaint, it still doesn't fit within the insuring provision. There still has to be coverage. If there's no potential coverage.
I understand that, but you basically, at the end, if they win this case, the mortgage is rescinded.
If Ms. Brown wins the case, it's rescinded subject to certain. The case is over, but if she were to have won the case, the mortgage would be rescinded. That's correct.
You may say that's an incident of the loan being found, but that's the consequence of the suit. And in a liability insurance policy, if the consequence of the case is that there would be a loss, there'd be coverage. So since there would be a loss of the mortgage if they were to win, why is it to be different from you unless we're going to treat title insurance
differently? Certainly, Your Honor. I believe you've mixed two standards, so I want to comment on what I think the mix-up is. A title policy is not similar to a liability policy in that if the mortgage goes away, we don't have necessarily a loss to pay. It's an indemnity-only policy that covers only an actual loss to the insured. In this case, for instance, if it was rescinded, there might not be a loss. The mortgage would go away, no doubt. The mortgage is rescinded and, quote, lost that way, but there may still not be a loss under the policy. In other words, if Ms. Brown was ordered to pay back the principal and the principal was worth more than the property, the title company wouldn't have a loss. But I don't think that was your question. I just point out that
Duty to defend, though, is you pay attorney's fees, will pay the costs, attorney's fees, and expenses incurred in defense of the title or lien of the insured mortgage. And the policy insures against loss or damage sustained or incurred by the insured by reason of the invalidity or unenforceability of the lien of the insured mortgage. And what your brother is saying is that if they win, there will be loss or damage arising from the invalidity or unenforceability of the mortgage. And that's true, isn't it?
it's true that if Ms. Brown is successful on her claim attacking the loan, that the mortgage as an incident to that would be rescinded and therefore, in simple terms, would be unenforceable. This is, however, the same phrasing that was discussed in Pacific American and in Lawyers Title v. JDC, where they said that this provision, when you read it, when you say the loss has to be by reason of the invalidity or unenforceability of the mortgage on title, that it wouldn't pick up that scenario because that is an attack on the loan and underlying debt. And even though the mortgage goes away, it's simply an incident. It also goes on, Your Honor, to suggest in that it's not the reason that there's a loss. In other words, the unenforceability of the mortgage in those circumstances is due to something that's wrong with the loan. It is not title. It is not a defect in the mortgage. And I think when you review the cases cited in our brief, you'll see that the interpretation of that provision means that the loss has to be by reason of a defect in the mortgage upon the state of title. And that's what it says.
It says that the loss or damage by reason of, that the insured suffers loss or damage by reason of losing the enforceability of the mortgage. Doesn't it?
It says the loss or damage has to be by reason of the unenforceability of the lien of the mortgage on title. That's what it says, Your Honor, correct? But when you put it in what title insurance is and how it's been interpreted, I still believe that there's a critical distinction between the underlying loan being attacked and the mortgage. There's not one case that Deutsche Bank has cited, nor have we found, in which the mortgage being rescinded as an incident to some problem with the loan has triggered coverage for a title policy. And I think that unless the Court wants to ask further questions,
I
see my
do
time is
have
up.
one question, if I could ask.
Certainly, Your Honor.
It's about exclusion 5.
Yes, Your Honor.
Now, Mr. Briansky says consumer credit protection is pretty specific, and it isn't 93A. And what this complaint alleges is 93A. It doesn't allege any of the federal or state statutes about consumer credit protection per se. Right?
It doesn't specifically reference those. We would agree with Judge Haggerty in the court below that that provision should be interpreted broadly due to two things. The one, the term any, so it's any consumer credit protection law. And also, if you note, it says usury, consumer credit protection, or truth in lending. So while RESPA, HOIPA, Truth in Lending, the Mass Consumer Credit Cost Disclosure Act are all truth in lending statutes, the phrase consumer credit protection must mean something other than your typical truth in lending law. And the phrase law also is broad. It doesn't have to be a specific statutory claim. It could be a common law claim.
But if we interpret an exception to the policy against you, I mean, in other words, that you've got the burden of proof on it, obviously.
Certainly, Your Honor.
Shouldn't we be looking at it pretty narrowly? I mean, in other words, when it doesn't say consumer protection, it means no consumer protection.
We clearly have a consumer credit protection. We clearly have an underlying transaction that is a consumer credit transaction. The basis of the claims all relate to that consumer credit transaction. And I think the case law, and we've cited in our brief, says it's not the whim of the pleader, it's really what the claims go to. So when you look at a pro se plaintiff or someone who perhaps files through a legal assistance bureau or an attorney who doesn't specifically plead RESPA or HOIPA or TILA or the CCDA, I think you have to look at what the transaction is and what the allegations are. And I think that when you look at the complaint as a whole and what she's arguing, I think it does fit within consumer credit protection laws. and I think that is the claim. I also think that the failure to comply with the insuring provision 5, we don't need to get to the exclusions.
I understand you do. I was
Thank you, Your Honors.
All right, thank you, counsel. We'll take a brief recess.